you here. I want to begin by thanking the Chief Justice of the Lahore High Court, Justice Jawad Hassan, the Punjab Bar Council, the organisers of this event. I'm delighted former Attorney General Ashta Saab is present here. And for me it's a great pleasure to be able to share with you some of my experience on a subject that is at the heart of what you do, namely advocacy. I've been a practitioner now, a barrister, QC for 13 years, a barrister for 15 years before that. And I've done hundreds of cases in the English courts, arbitrations all over the world, the ICJ case, recently for Pakistan, the Yadav case. And I'm also doing a case in Africa, in Kenya, in the High Court in Kenya. At all of that experience, I want to try and share with you in the next 20 minutes. Because as advocates, it doesn't matter which kind of court you appear in front of. In fact, each and every one of us during our life acts as an advocate in some way, shape or form. So if you're a parent, you're trying to persuade your children what to do and what not to do. If you're a friend, you're trying to do the same, and quite often friends don't listen. Maybe it's a question of style, maybe it's a question of technique. Sometimes the harder you try, the less easy it is to persuade. Gentle persuasion often works better than force. And there are some principles I want to share with you in terms of advocacy, because, alhamdulillah, in Pakistan there's no shortage of talent. On the bench, at the bar. I have been very fortunate, very privileged to have done work involving 60, 70 states, from Russia to the USA to Germany, having done work for India, Pakistan, Africa. And there is a common theme. Our job as advocates is to persuade. It's to persuade whoever's listening. It doesn't matter if it's 16 judges in the ICJ. It doesn't matter if it's a room full of people of this nature, or thousands of people. I've addressed thousands of people in the course of my career. I remember in China in 1998 having to address a room of 5,000 Chinese people, most of them wearing a military uniform. And it was a bit difficult to tell, one, whether or not they understood what I said, and two, whether or not they actually were taking on board and implementing. But this is 1998. Now, there's a point that I want to make here, which is not on the subject, but a point that I emphasize again and again. Pakistan has enormous potential in all of you and in the entire population. In the 1990s, the Chinese didn't have a sophisticated commercial law system. When I was there in 1998 as part of the British government delegation, we were explaining to the Chinese commercial law, constitutional law, insurance law. 20 years later, we know where the Chinese economy is. It's the most powerful economy in the world. 20 years later, who are the major investors in developing states? It's the Chinese. What's the lesson? If they can do it, so can you. And that's the same so far as advocacy is concerned. Now, what I want to be able to share with you is the explanation as to what the role of an advocate is. And you have three responsibilities as an advocate. The first and foremost is to assist the court. Now, when I act as an advocate before the English courts, and even anywhere in the world, I take my code of ethics with me. And the code of ethics requires me to act honestly, not to mislead, fairly, and to assist the court. We all operate in what's known as an adversarial system. You have somebody arguing against you, and you're trying to argue a point. The judge isn't supposed to be the third party in the argument. The judge is supposed to listen and decide. So the judge relies upon you very heavily, or the judges rely upon you very heavily, to present the facts, to present the law as clearly and as simply as possible. And whilst you have your duty to the court, you also have your duty to the client. The client is somebody who may have entrusted a hugely important matter to you. It may be a question of liberty. They may have been prosecuted for murder, they may be subject to a death sentence. It may be a huge business that has exposure of tens of billions. I've done commercial cases involving claims of tens of billions of dollars. For the client, this may be the one and only opportunity they have for somebody to listen to what they're saying and for their case to be presented. For you, there may be 2 or 3 cases in the day. You may be going in the criminal court, and you may have a roster of cases that you've got to deal with. But never forget, it's easy for me to say, but it's extremely important for you as lawyers. Each client deserves, and each client expects you to give them equal attention. It doesn't matter whether they're rich or poor. It doesn't matter whether they're big or small. It doesn't matter whether it's the state or somebody against the state. Each client deserves equal attention. Remember that. Because your duty is not just to the court, it's to uphold the rule of law. And what is the rule of law? The rule of law ensures that everybody is held accountable, that everybody is equal, that a society that is based upon rights and obligations doesn't favor one group to the disadvantage of others. Last night I was hosted at a dinner by some very bright, committed, idealistic young lawyers. I'm not going to mention any names. And I was very pleased to hear what they're doing. They're taking up causes of the most disadvantaged. And how do you test the health of a legal system? How well does it protect the most disadvantaged? The companies that I act for, the states that I act for, have ample resources. They can spend tens of millions, sometimes hundreds of millions on legal fees. But what about the orphan? What about the child that's been abused? The woman that's been harassed? The individual who's subject to oppressive use of force? Who's going to defend them? The answer is you are. And you mustn't hesitate to defend them in accordance with the law, because you are there to assist the judiciary to uphold the law. And in doing so, remember, you have ethical requirements to act honestly, to act fairly. A court is not a theatre. A court is not a boxing ring. A court is not a cricket pitch. I'm going to develop this further because ultimately, if you don't uphold these 3 elements, the duty to the court, the need to prevent your client's case effectively, fairly, act within the boundaries of ethics and etiquette, being polite, a legal system unravels. Next. Now these slides can be shared with you. It's very small print. Unless somebody's got far better eyesight than me, I'm not going to try reading them. So I'm just going to tell you what I believe you should do to assist the court effectively. First and foremost, your submissions should be succinct. Everyone know what I mean by succinct? Summarize. Very, very often, I was what's known as Treasury Counsel. I used to do a lot of work for the government. For 6 years, UK government. Judicial review, constitutional challenges. And lawyers are the same everywhere. If they have a bad case, they spin it out. They try and delay to get an adjournment. And they throw lots of material at you. Very often they're well paid. You're acting for the government, and you're acting on generally a very low rate. I would call it a charity rate. So I did my charity for 6 years for the government. And your job as the lawyer is to ensure that you provide the court with up-to-date case law. That if there's comparative material, you provide it to the court. The facts are presented in a summary way, clearly, crisply. Ideally, assist the court by providing the court with written submissions. In England, we produce what are known as skeleton arguments. Maximum 25 pages. I have just done a case where we had 90 bundles, this big. 90. My skeleton argument was 25 pages. Because that's the maximum limit for the court. Lawyers, the longer you give them, the more time they will take. And therefore, discipline yourself. Force yourself to say, I'm going to take as little time as possible. I remember when I did the provisional measures hearing in May 2017, I understand somebody in Pakistan said, well, he had an hour and he only took 20 minutes. Well, that's because I wasn't there to waste time. I was there to use time efficiently. If you want to persuade a court that you are right, you help the court focus on your arguments. And in terms of focusing on the arguments, don't waste time. Help the court. A person who wants to make a decision, who has to make a decision, needs to be assisted. And the more assistance you give the court, the more likely the court is to find what you're saying as being more helpful than the other person. And in terms of assistance, I don't know what the position is in Pakistan, but in Kenya I discovered that people can give authorities at the last minute, which I think is the same here. And in England, no. In England, you must serve your written argument 3 days before the hearing. You must produce agreed bundles of documents which have page references, which have an index, agreed. You can't go to court and say, by the way, I've just found this, by the way, I've just found this, and this. What's the reason? So that you're all looking at the same material, the judge is looking at the same material, and when you're producing a skeleton argument, you're giving a judge a route map on this material. Don't bombard your opponent or the court with documentation. There is one legal system which is also a common law system, and if anybody has studied in America, I'm not seeking to criticize the Americans, but because they're worried about professional indemnity claims, somebody suing them, American lawyers tend to throw everything at the judge or at the arbitrator. Every single argument they can think of. There's a long list. It's like, if you look at a written submission made by American lawyers, the index is more like an index to an encyclopedia. And how many of us like looking at encyclopedias? Well, if we want to find something in the encyclopedia, we're happy to do it. But to have to read through the entire encyclopedia just to find what's relevant doesn't really make sense, does it? So have enough confidence in yourselves to identify what the proper arguments are, as opposed to wasting time. How can you assist your client most effectively? First and foremost, by being seen to be an officer of the court. When I say an officer of the court, somebody who behaves with respect to the judges, who commands the respect of the judges. That's extremely important. We have the Chief Justice of the Lahore High Court here, Justice Jawad Hassan. We have the Attorney General, former Attorney General of Pakistan. The former Attorney General of Pakistan had to appear and has to appear before courts to represent the government in sensitive, difficult cases. And the advocate has to persuade the tribunal, doesn't matter which tribunal it is, Supreme Court, High Court, but the point of view that they're putting forward is the one that the tribunal should accept. If the tribunal doesn't respect you, that's unlikely to happen. And they're likely to respect you if they see you as somebody who plays fair, who doesn't ambush, who isn't hostile, doesn't try to bully their opponent, who doesn't exaggerate their case, who doesn't lie. No one likes liars, and I certainly don't like liars. I detest liars, but for me, I actually am happy to see a liar in one place. That is the witness box when I'm cross-examining them. That is where I'm very happy to see a liar. But other than that, if it's an opponent, and an opponent in England, I've not come across, in hundreds of cases, I've not come across a barrister who has lied in court, ever. And that's fundamentally important. When you're speaking, and you're finished, you have a right of reply here, I suspect. If you're the claimant, the defendant comes in, then you come in at the end. The right of reply is actually extremely important, because it's where you summarize your case, but you don't repeat it. Equally, when you're on your feet, use that time wisely. Don't waste your time. Check whether or not the judges have read what you've sent them, the written submissions. I know, I've heard about the enormous list that the judges of the Lahore High Court, Justice Jawad Hassan, prolific judicial industry in the sense of having to deal with numerous cases on a daily basis. In England, if I tell you in the commercial court, which has 12 judges, we only had 70 trials, 70. But one trial can take 6 weeks and can have millions of documents. And that from start to finish, from issuing a claim in the commercial court to getting a judgment doesn't take more than 2 years. That gives you an insight as to how quickly the process works in England. We can't get adjournments. I don't remember the last time I saw a client or an opponent obtain an adjournment. So if your client's asking you for delay, and if you're asking for delay because you happen to be double booked in 2 different courts, in England that's a disciplinary matter. A lawyer cannot be double booked. The lawyer can be the subject of misconduct. Professional ethics and etiquette. What are the ethical boundaries of your jurisdiction? There is a code of conduct here. And I've looked at it, it's not very different from the one in England. And the principles are very simple: to act honestly, to be fair, not to mislead the court. Those are very simple principles. Lawyers can be tempted to break those principles. Ego, pressure from the client, a desire to win. They may get away with it once, they may get away with it twice, but when they're caught out, that's it, finish. I have seen examples of lawyers who behave this way. All of a sudden, they acquire what people consider to be a phenomenal reputation, but then they collapse. Why? Because they get found out. There are examples of misconduct in the USA and the UK. And a lawyer who is found to have engaged in misconduct is finished. I would advise any bar counsel anywhere in the world that misconduct and rooting out misconduct is critical. I'll give you an example. I mentioned I was in the Kenya High Court, or maybe I didn't. I was doing a case involving a judge. I still am doing the case involving a judge. And one of the 11 counsel against me for the judge was tweeting. He had his own camera in the side of the court. No doubt he was also looking in the mirror at the same time, making sure his audience was watching him. He issued a tweet which was critical of the government. And no one ever in Kenya before the High Court had asked the judges to reprimand a lawyer. But I did. And this gentleman was formally reprimanded by the judges for what he'd written. And I was surprised that no one has ever done that before. But having done that, and he was reprimanded, we will wait to see whether he does it again, because if he does, then the Bar Council may well have to take action. The point being, there's always a first time. And the Bar Council shouldn't hesitate. Examples have to be set, and you must uphold standards. Whilst we operate in an adversarial system, by which you understand the difference between adversarial and inquisitorial. The civil law system, which is mainly in continental Europe, the judge is the one who asks the questions, and the judge doesn't allow much by way of oral submissions, it's mainly written submissions. In our system, which is the inquisitorial system, the facts are the subject of competing submissions, and the law competing submissions, so the judge can decide between the two. Now, just because you're on different sides doesn't mean that you have to fight each other verbally or physically. You can achieve the same objective as an advocate by means of understatement. Everyone knows what I mean by understatement? Don't exaggerate your position. You're trying to persuade a judge. Generally, it's the judge who thought of the point, not you. I didn't understand this when I started practice, but your job as an advocate is to create a picture in the mind of the judges. You're creating a mental picture, and then the judge fills in the gaps. That's your job. Your job is to help the judge. Every case is like a jigsaw puzzle. And that's a challenge, and it's also fun. Every case is like a jigsaw puzzle that someone's thrown up in the air and the pieces all over. And your job as the advocate is to describe the jigsaw once you put it together to somebody who can't see it as clearly as possible and as quickly as possible, so they see exactly what you're seeing. That's the job. Not distorted, complete. And don't forget, there are many advocates who make their reputations because they're seen to be good speakers. Maybe people believe that they have an ability to persuade. But ultimately, as somebody said to me right at the beginning of my career, it takes decades to build your reputation, and it takes minutes to destroy it. That's in a system where you're judged by your performance. Likewise, complacency as an advocate, as we become senior, and I'm afraid now I have grey hairs, and the bags under my eyes testify to how many sleepless nights I've had working, but I've enjoyed every single one of those. I love what I do, and that's how you should feel. Because no amount of money can force you to look at hundreds and thousands of pages. It's because you're curious, getting up at 2 o'clock, 3 o'clock in the morning to prepare for a case. The moment you feel you've had enough is the moment that you should slow down. Actually, is the moment you should walk away. Because of what I said to you right at the outset. The client, the duty to the client expects you to do your best. Every client expects you to do your best. You have an obligation to the client to give them 100%, not good enough, 100%. That's how you should feel about what you do as an advocate. And if you do, the system will grow stronger, the judges will respect you, and you will be not just the guardians of the rule of law, but you will be helping the judiciary uphold the rule of law. Thank you. That's what I want to give you by way of overview. I understand we've got some time for questions. Very short questions, please, relating to what I've said. If you want to ask me a question, just raise your hand, explain who you are, just speak loudly. I don't believe we've got a microphone. Far away. Hands up. Malik.
So you talked about ethics in the legal profession and advocacy. How important are these according to you? And do you think that they are getting out of vogue now that the legal profession is becoming corporatized across the globe?
That's a very good question. I can tell you in the first year of my practice, as a baby junior barrister, I did a case in the Court of Appeal in front of 3 judges. The judge in the chair was a very, very eminent, very, very highly respected judge. And my clerks, I was against a QC, said to me, "You're before Sir Roger Parker. Sir Roger Parker is fearsome." So I went, baby junior, I was in the Court of Appeal. By the time I got back to chambers, this was in the days before internet, the clerk said, "Well done." "What do you mean, well done?" "Well, you won." I said, "Yes." "How do you know?" "Well, Sir Roger Parker has contacted us and he's going to come and talk to you after tea." So I got feedback from the judge, and that was wonderful for me, because the judiciary, believe it or not, knows who are the good advocates, who are the bad ones, who are the rotten ones. The judiciary knows. And your job is to persuade them. So you want to be seen as the star of the class, not quite teacher's pet. The difficulty we have is, as cases become more complex, and as more money is involved, and the consequences are greater, there is a temptation, a very big temptation for people to cut corners, to accidentally avoid giving documents that they should have done, to encourage a witness to say things which maybe they shouldn't be saying, to drag the case out longer than they should, maybe because they want to ensure they can buy a brand new car, pay school fees, buy a big house, go on holiday. All of these are wrong. Absolutely wrong, but you're right in the sense that this is happening because people are moving away from the idea of being a lawyer as a vocation to being a lawyer as a business. And we're not business people. A case isn't an opportunity to maximize profit. A case is an opportunity to enjoy yourself in what you do as an advocate, to deliver an outcome, to do your best, and even if you don't win, so long as you believe you've done everything you could to advance your clients as fairly and as effectively as possible, you've done your job. Because in every case, someone has to win and someone has to lose. Next question.
Legal ethics, in my opinion, is a matter of either subjective or objective opinion. Can you elaborate on that?
Tell me how that you can say that. Is whether or not someone's dishonest a matter of objective or objective analysis or subjective analysis? I'll tell you the answer. Whether somebody has told a lie can be demonstrated objectively. So is it night or day outside? Well, I'm telling you it's night, it's pitch black. Go and have a look at yourself. It's day. That means you can test what's being said objectively. And that's the point. Honesty can be tested objectively. Fairness can be tested objectively. Not to mislead can be tested objectively. Because if I just said to you, it's night outside, you can demonstrate I'm wrong because it's not, it's day. Do you understand?
Can I continue?
I don't know where the microphone is. Did everybody understand the question? It's not subjective. It's not like beauty is in the eye of the beholder. Truth is objective.
So not everything can be a black and white.
Sorry?
Not everything is a black and white debate. At times there are gray areas between.
That's.
A very complex proposition.
I think every one of us has heard that excuse throughout our lives. I've never used it. Frankly, I'm sorry. There is black and there is white. There is good and there is evil. And those who want to blur the distinction are the ones who want to take advantage of ambiguity. As lawyers, people like me as a commercial lawyer, love ambiguity. What is the difference between and, or, a colon and a semicolon, a full stop? That's something that I'm very familiar with because on big commercial contracts I spend hours analyzing what a word means and how the ambiguity can be resolved this way or that. But in matters of truth, in matters of honesty, in matters of integrity, there is no ambiguity. Somebody is either clean or they're dirty. Somebody is either corrupt or they have integrity. A society declines and a society is demoralized when people accept less than their best. And when you say that it's not black or white, that is when you're opening the door to moral decline. So resist that temptation. Next.
Thank you very much for your time. First of all, my question is that if the client wants us to lie with the court.
Sorry?
If the client wants us to lie with the court.
To lie?
Yeah, to lie.
Do you need to ask me that question? Do you really need to ask me that question? I'll give you an example. I did a case, a very sensitive case for the Russian Federation. It concerned a politician who, Mr. Putin, it's in the public domain, I'm not telling you, and I couldn't tell you anything, as in the context of ethics, I can't tell you anything about a case where the facts are confidential, or where I've given advice to a client which is privileged. Remember that. Okay? And I can't act for Mr. A or Miss A today, and Miss B is on the other side, or Mr. B is on the other side, and then 6 weeks later, switch sides and go to Miss B or Mr. B. I can't. That's conflict of interest. They're basic fundamental principles. But I remember doing a case for the Russian Federation. It was a very sensitive case concerning political opponents, and a very well-known actress from England, some of you may know who she was, I'm not going to say the name, was in court, and a billionaire was funding this person, and I was representing the Russian government. And the actress who knew me outside court said, "This is outrageous, you're acting for this person." Now, the Russian Federation didn't tell me that they were telling untruths. If a client tells you that they're lying, you say, "Thank you very much, go to Mr. X." What do you mean go to Mr. X? Well, everyone knows he's dodgy or she's dodgy. Go to him. And if the judges know what they're doing, that's virtually guaranteed to ensure that that person is going to be sentenced for the crime that they've committed, because if they're lying, a decent judge will spot it. Okay, so what's tempting, and I know that in some jurisdictions people will laugh at me and say, don't be absurd. This is what we're asked to do every day of the week. Well, you start saying no. You start saying no to conflict of interest. You start saying no to, can I have a look at what they said? Breach of privilege. And the more of you that say no cases based upon constitutions, the Kenyan case that I've mentioned is based upon constitutional principles. Remember what I said right at the outset. The tools of your trade are not just your ability to persuade the facts and the law. It's how you use them that matters.